Hi, we are going to present the case, the Bhopal case, Charan Lal Sahu versus Union of India. Me and my group members will be presenting the case as the defendant, that's Union of India. And I'll introduce all the group members. This is Jagdeep Bajwa, and the student ID is GKE3053. And then followed by Balwinder Sekhon, NPI 3034, followed by Rupinderpreet Singh, NPI 3040, Navjot Kaur, AZZ 3070. I'll be introducing the case and then followed by my friends with the arguments and then the conclusion. This is the Bhopal case, was the most talked about case in 1984 when Union of India, that's Union Carbide Limited, there was a subsidiary company of Union Carbide Corporation. That was a New York company. They opened one of their branch in Bhopal, the city of India, as Union Carbide Limited India. They used to produce pesticides using methyl isocyanate. That was a highly toxic gas. And in this case, that on a night of 2nd and 3rd December 1984, the gas leaked and there was a huge unrest in the public. There was around 30,000 deaths, and there was also a huge loss of flora and fauna around the city. There were many people who got injuries who were alive, and obviously there was a number of deaths, about 3,000, sorry. And for that, many of the cases were filed in New York against the company, and then later on these cases were brought to India, obviously because there was a number of victims who had to file the claims against the company. So there was an act passed. There was Bhopal Gas Disaster Act 1985. That act was passed by the government of India to represent all the victims so that they don't have to file the case on their own. This case, which we are talking about, Charan Lal Sahu versus Union of India, that was a case which was filed against Charan Lal Sahu. He was the petitioner, and he was also an advocate in the Supreme Court who passed the act. He filed the petition against government of India not to act as a parents patria, that is not to represent all the victims, because he was thinking that government of India was also one of the culprit in the leakage of gas and then the deaths and the loss of flora and fauna and obviously the human beings. So he actually filed a petition in the Supreme Court that the government of India is not doing, he has no right to take all the claims, to file the claims on behalf of all the victims, rather than the victims should do themselves. Then my friend will follow on with the arguments in the case. Thank you.
Hi, it's Balwinder Sekhon. I'll be proceeding this presentation furthermore by discussing its various issues about the case of Bhopal Gas, Charan Lal Sahu versus Union of India. The first and foremost was the act valid according to the Article 14, 19, 21 of the Fundamental Rights under Indian Constitution? And another one, principle of natural justice, which is Union of India was a tortfeasor, and it setting up such plans as such, it is against the principle of natural justice, and that it is filing the case on behalf of victim of these factories without safeguard. And another one, which is central government has a conflict of interest and has no right to appeal. And the last one, were the victims and their families given due opportunity of being heard?
My name is Navjot Kaur, student ID AZZ3070. The case is the Bhopal case, Charan Lal Sahu versus Union of India. Now I'm going to represent about arguments in favor of Union of India. The Supreme Court of India ruled the decision in favor of central government of India on the basis of the arguments. The basic assumption behind the act was the payment in interim compensation by the government till the time of actual compensation is duly received by the Union of Carbide of India and USA. The next argument is the government was only acting as an intermediary and representative of the victims, and by no means is it trying to pass judgment. The right of adjudication will remain with the court itself. The right of government representation is arising out of the doctrine of necessity. The next argument is even in the case of conflict of interest, the government intervention was necessary due to the absence of an equally strong alternatives. The next argument, the court proceeding itself is a proof that the victim and their representative are given proper chance of redressal and will be allowed the same in all future circumstances. The nature of the case was such that it was practically impossible to hear the views of each and every person affected by the tragedy because of the sheer size of the population affected. The next argument is the government-owned organization LIC and Unit Trust of India, not the government itself, had any stake in Union Carbide, so no point of conflict of interest. The next argument is that the act was passed to allow the directive principle under the section 39A of the Indian Constitution. It is an act passed under special circumstances, so the central government was given certain special rights to fight of the victims. Thank you.
My name is Rupinderpreet Singh. My student ID is NPI 3040. Today I am here to present the Bhopal case, Charan Lal Sahu versus Union of India. The application had been filed by an advocate of the Supreme Court by the way of the public interest litigation. It had been listed earlier and learned Attorney General had internal appearance on the behalf of the Union of India. Furthermore, on the basis of the above argument, the Supreme Court of the India ruled in the favor of central government, but along with that it stated that act was passed in hurry. The court realized that the scale of the disaster and the complexity of the issue was such that the certain powers could have been given to the state only on the count of disability of the victim to seek justice. In the end, the exclusion of the victim from filing their own case was held to be proper. The court also held that the act only deals with civil liabilities and as such does not curtain or affect rights in respect of criminal liabilities.